Now, let's just do this in a little bit more detail. Legal infants are persons under 18 years of age and cannot enter contracts except for the supply of necessities. Necessities might be food and shelter. People of unsound mind or under the influence of alcohol or drugs are believed not to have the ability to understand. However, a return to a sober or a lucid state can ratify the contract. Ultra-vires. Now, we came across this before. Ultra-vires companies cannot act outside its constitution. If it does, there is no legal contract. And diplomats, these can claim diplomatic immunity and therefore have no legal capacity to contract, as they act for their nation and not themselves. Now, as I said to you before, the capacity to contract has come up on a number of occasions on the exam. Legality of form. If a contract is required by law to be laid out in a specific manner, then it must be laid out in that form, otherwise it is not valid. For example, a simple contract can be oral. Complex contracts must be in writing. Hire purchase must be in writing. Contracts of employment must be in writing. Contracts for the sale of property must be in writing. Legality of purpose. To be legally binding, a contract must have a legal purpose. If an illegal contract exists, then no action can be brought for a breach of it. Now, this is very interesting and has never come up. If any of the above four elements are not adhered to, the contract may be declared void, voidable, illegal, or unenforceable. Void, it never existed in law, but it did exist in fact. Voidable, it may be set aside. Illegal, no action can be taken on the contract. Or unenforceable, the contract is good, but it cannot be enforced. For example, one party had no legal capacity. Now, here are a number of terms that have been used in contract law. Privity of contract. This means that the rights and duties following any contract only belong to the actual parties involved in the contract. Third parties have no legal rights. Terms of a contract. Expressed terms. These are terms which are clearly stated. For example, to build a house according to the plans. An implied term. These are not expressly stated, but implied by provisions of a particular law. For example, the provision of the Sale of Goods and Supply of Services Act 1980. The wood and the bricks used to build the house must be of merchantable quality. Now, that's not going to be stated in the contract, but it's implied in the contract. A condition. This is a part of a contract which is fundamental to the contract. If a condition is broken, the contract may be cancelled and damages sought by the injured parties. For example, if a person booked a holiday in Portugal, but was informed the day before leaving that the resort was booked out, but offered them a resort in Scotland, then a condition had been broken. A warranty. This is part of a contract which is not fundamental to the contract. If a warranty has been broken, then the aggrieved person may seek damages but may not end the contract. For example, if when the person arrives in Portugal, they find that the hotel does not have air conditioning or a tennis court as promised, then a warranty has been broken and the customer can seek damages. Now, the next two parts, termination of a contract and remedies for breach of a contract, have both come up in the exam. Contracts can be ended or discharged in four ways. Performance. Both parties to the contract actually carried out their side of the contract as originally agreed. The house was built and the money was paid over. Agreement. Both parties to the contract have an agreement that they would be better off ending the contract. For example, the manager of a football team. Breach of contract. One party of the contract breaches or breaks a condition of the contract. This in turn gives the other party the right to end the contract. And finally, frustration. Events which make it impossible to carry out the contract frustrates the contract. For example, a concert may be cancelled due to storm damage. Now, lastly then, we're looking at outline the remedies for breach of contract. Cancelled. The contract may be cancelled or rescinded, and the innocent party can have the contract set aside and to be restored to the situation they were in before the contract was begun. Damages. Financial compensation is usually the main remedy. And specific performance. Now, this has come up as a short question. The court can order that the terms of the contract must be carried out as originally agreed. Specific performance is used when the money or damages is not an adequate remedy.